Welcome to Legally Speaking with me, Tarun Nangia. The issue of dying declaration is always in great discussion in many important criminal cases. And rightly so, Justice Pardiwala and Justice Suryakant have authored a judgment. Justice Pardiwala has authored the judgment, and it was decided by a bench of these both judges, Justice Pardiwala and Justice Suryakant of the Supreme Court of India, where they said that the dying declaration should be subject to close scrutiny. And they have made a series of points. And that is what the show is about today, the issue of dying declaration and the observations made by Justice Pardiwala in the judgment. May I introduce an eminent panel today to you? I have with me Senior Advocate Shishadri Naidu, who joins us on the show. Good to see you. I have with me Atmaram Natkarni, Senior Advocate. He served as the Additional Solicitor General of India. Good to see you again. I have with me Senior Advocate Geeta Luthra. Good to see you again. And Niharika Karanjawala Mishra. She's with Karanjawala and Company. Good to see you, Niharika. And looking forward to some interesting interventions from all of you. At the outset, may I request Senior Advocate Atmaram Natkarni to open the discussion before we move on. If you lay the ground, what happened in the court, and then we can start the discussion.
Yeah. In fact, Tarun, the whole idea of accepting this statement comes from a old maxim. The old maxim which says nemo moritus prasimatur mentar, means a person who is about to die will not, will not have or will not want to have any lie in his mouth. You will also recall the statement which is in fact quoted in the judgment, Matthew Arnold's statement, that the truth sits upon the lips of a dying man. Of course, in today's world, frankly speaking, in the lighter vein, it's very difficult to accept this statement very, in a very blind manner. But the courts over a period of time have developed. One of the things which is developed is that the oral dying declaration can form the basis of conviction. There are cases where the courts have sought corroboration. Whether the corroboration is forthcoming or not, that's in a given case. But the sole dying declaration can also form the basis of conviction. Is that far the law has gone? Only thing, insofar as dying declaration is concerned, there are certain foundational requirements and certain further requirements. Because the foundational requirements are the person must be, at the time when he makes a declaration, he must be in the actual danger of death. I mean, it can't be that anybody taken to hospital starts, I want to give a dying declaration and dies because of some remote cause somewhere. That can't be. So he must be in actual danger of death. Number two, he had full apprehension of the danger, namely that I'm going to die. Thirdly, it is mandatory that the death must have occurred after that particular declaration. And fourthly, if he was alive, he would have been a competent witness. So these are the four foundational requirements of a dying declaration. But at the same time, for a dying declaration to be admissible in law, the requirements are that it must relate to a statement which concerns the cause and surrounding of the circumstances of the declarant's death. This is one other basic thing. And it must be made at a time the declarant was conscious and was also conscious of the fact that there is an impending death which he is going to face.
Point. Thanks for that introductory comment, Senior Advocate.
So these are, the various requirements, but at the same time, what I would like to highlight is what is highlighted by this bench of the Supreme Court of Justice Suryakant and Justice Pardiwala is they have accepted that dying declaration. They have said if the court is satisfied with the dying declaration, see, ultimately don't forget that the trial court gets to see the demeanor of the witness. The person who conveys the dying declaration must instill confidence.
That's a physical
one. But
physical courts become important when you speak of demeanor.
That's
Because
right.
on an online hearing, you absolutely can't make out what the demeanor is. And I'll go to Senior Advocate Geeta Luthra, who's argued many such matters. Ma'am, your opening comment.
So I feel, despite this judgment of the Supreme Court, I feel as perhaps Mr. Nadkarni may have voiced a little more delicately, is that we have to take it with a pinch of salt.
Yeah, that's what he said.
Yes. So we have to take it with a pinch of salt. We have to see and we have to make that distinction between English law and Indian law. And the fact that the Indian law does not envisage the same very requirements that the English law does. And to some extent, I wish it would. So we've come a long way from the strict definition of dying declaration being made to a magistrate, where there are question and answers, where it is in the, not necessarily, but normally in a written form, reduced into writing, and those parameters which were there. Now here in India, it need not be that the person is so fully conscious that he is going to die and that he realizes that it is his last statement. So why is it said that lips of a dying man will not speak any lie? Because that man should be conscious that, look, there is a likelihood I will not survive. I am going to my maker. And since I'm going to my maker, I should not be lying, because there was that sanctity attached to a dying declaration statement. Now, over the years, because of the need of a higher rate of conviction, the fact that dying declarations may not be in that sacrosanct language which dying declarations were originally envisaged, now oral dying declaration. As far back recently as in 2014, a bench of Justice Ranjana Desai and Justice Lokur, and I think the case is called something versus Wazir, said that normally dying declarations, oral dying declarations, should have corroboration. So what marks this judgment to a large extent is it's an oral dying declaration made to a person who was a neighbor in a paddy field who saw him crossing. It doesn't show that this man knows he's going to die. It's true that the medical evidence shows 75% burns. But I've perhaps talked to some experts, doctors.
Yeah. See, today we focus on the law point rather than this particular case, which is...
Yes. So what I'm saying is that forget this case, look at the law point. Is the person, or was there a perception that this man knew that I will die? And so this question does not come out from the judgment, perhaps, but from the 75% burns. So this aspect of it, which distinguishes the Indian law, Section 32 of the Evidence Act, from the English law, is what we need to look at further. And the effect of this judgment, which is saying oral dying declarations without corroboration are good enough for a conviction under 302.
Point well taken. And before I go to Senior Advocate Sheshadri Naidu, I'd like to say one or two things. First of all, I could see there was some skepticism when Senior Advocate Atma Ram Nadkarni answered that these days you never know. There may be dying declarations. Could they also go wrong? And that is why I would like to get in Senior Advocate Sheshadri Naidu. We all know he has served as judge in various high courts around the country and would have, in a sense, heard many lawyers and also seen cross-examination and delivered judgments on such issues. So, sir, could you distill your experience of all these years and share with us?
Justice Naidu was one of the finest judges, Tarun. I must tell you, one of the finest judges. I don't know why he resigned. It's a loss to the judiciary.
But I think it's the bar's gain. It's at the Supreme Court as a senior.
Probably it might be for his own gain that he has resigned.
Thank you, Tarun. And I'm grateful to my friends, Mr. Nadkarni's very kind words. And to begin with, Mr. Nadkarni has beautifully put the fundamental principles are the first principles of dying declaration. Then Madam Luthra has expanded on that one, and she has pointed out the jurisdictional changes between the English law and the Indian law, and also the practical nuances of this application of principle. Now, as you have said, yes, they could go wrong. And the vexed question as far as judiciary is concerned, whether a dying declaration requires corroboration. And let me put that in perspective by telling a story. It takes 1 minute, right? Long back, when Oliver Wendell Holmes Jr. was the American Supreme Court judge, there used to be a law clerk, a very young law clerk, that is learned hand. Later, he also became a legendary judge. He is most quoted, more quoted than the Supreme Court judges there. Then one day he had to go to his place, this learned hand. He saw Oliver Wendell Holmes after the court getting into his car and going by. He stopped him and requested for a drop. He got into it and got dropped at the place he wanted to. Then he waved his hand to the legendary judge, Wendell Holmes Jr., and said, "Dear Justice, please do justice." By then he passed a few paces. He backed up and came back. "Young man, what did you say?" Then this man flustered and said, "Sir, I said nothing except saying, 'Dear Justice, do justice.'" You know the classic reply of Oliver Wendell Holmes? "That's not my duty." Because according to him, the founder of the American positive philosophy, according to him, justice according to law. You take the present case that we have been discussing, right? In that one, don't you think there is some element of guesswork beginning from the trial court? When it comes to dying declaration, here to begin with, it's only circumstantial evidence. Then the dying declaration, he told to a person in the field, and then he went missing, then he died eventually. Then there should be a lot of, or some reasonable guesswork to what has happened. So beginning from 1958, Kushal Rao, the landmark judgment, to this day, it's been the consistent judicial view that yes, it is safe you have corroboration. And it is safe you have a recorded dying declaration through a magistrate, but you cannot discard oral dying declaration. You cannot insist on corroboration because peculiar circumstances, if they could inspire the confidence of the judge, satisfy the conscience of the judge, yes, that is enough.
So that is where the art of judging comes in, the wisdom of being a judge, the wisdom of judging cases. Is that where the discretion comes in? Where
yes, that makes a lot of difference. It's not a mathematical formula.
So it is the demeanor in court, then how you link the thing. So a lot is at the discretion and also the experience of the judge. Because
many cumulative factors, including the experience of the judge.
Okay. Thanks for sharing that with us. And I will go across to Niharika Karanjawala. Now, Niharika represents one of India's leading litigation law firms that deals with a lot of such matters. And I'll read out what Justice Pardiwala wrote in the judgment. A dying declaration, oral or written, before it could be relied upon, must pass a test of reliability, as it's a statement made in absence of the accused, and there is no opportunity to the accused even to put it through fire of cross-examination to test its genuinity or veracity. Very interesting statement here. I have seen lawyers and judges in the course of their careers grow very skeptical, maybe because they see a lot more of the trouble elements of society than the average commoner. And that is why that skepticism also helps in getting a lot of people get justice. As Senior Advocate Shashadri Naidu, who served as a judge, said that, it is at the wisdom of the judge and his experience at judging that helps him arrive at a decision. Niharika, your views on this issue?
I completely agree with that, Tarun. And in fact, let me say, I feel if I can add anything to what the esteemed panel has already said, I feel that what's truly important in this judgment is the attempt that the judges have made to create an equality and a balance between the rights of a victim and the rights of an accused. Because ultimately in a trial, the rights of the accused have to be paramount. They are the ones being placed at the altar of justice, and they are the ones to whom every consequence will fall from that judgment. And what I feel the learned court has done here is attempted to balance out the rights of a victim who is no longer present to put forward their case, and the rights of an accused who doesn't get the opportunity to do an accurate cross-examination. And in this situation, I feel what is very important is that the court has emphasized that if the circumstantial evidence is in line with the testimony, then corroboration is not required. However, if the circumstances in any way are disrupted, and in order to convict in a case of circumstantial evidence, the full chain of circumstance has to be completed, and the judge has to come to the conclusion that there is no other possibility other than the guilt of the accused. That's a very high bar. If all of those circumstances go and line up with the version that the victim has made, then it does provide a certain degree of legitimacy and reliability to the victim's statement. And I will say, Tarun, like you said, skepticism is rightly there. I am not an idealistic believer, perhaps like Matthew Arnold. I believe a lot of people go to their deathbeds lying. I believe a lot of people tell the truth when they are not in fear of death and of meeting their maker. And in every such instance, it is the role of a trial judge to parse what is reliable and what is not reliable. That is simply the daily job, and that is simply what they do. And that is, I feel, what is of the greatest significance here. Yes. That the circumstances and the facts of the case ought to, they themselves, in a sense, provide a sort of corroboration to this statement.
The point well taken. I'll take this to Senior Advocate Atmaram Nadkarni. When I heard you opening the discussion today, you said that, to the effect that you never know, even if dying declarations can come true today. Do you mean that the world and the society has evolved so much that, anything can happen? Absolutely anything happen, that along with 3 genuine accused, 2 non-accused may also get convicted. Do you think that's the dilemma we face as a society and the legal system itself?
Tarun, our whole emphasis is, that you must prove the guilt beyond a reasonable doubt.
Yes.
The burden is very heavy on prosecution.
Yes.
Now take this particular case. If you see this particular case, Justice Pardiwala in his judgment analyzes.
Yes.
In para 25, he says that particular Khetrapal, PW2, was a natural witness. There is nothing brought on by the accused that he had any axe to grind against them. It is natural for him to be there in the field. Then he says his evidence has been corroborated by the medical evidence which is brought on record, 75% burn injuries. Then he says trial court had the occasion to, that is how they've relied upon, and step by step.
But if we simply stick to the law point rather than the case, I would want to understand from you, is it a judge's dilemma always when deciding such petitions?
No, not only this petition. Judge's dilemma is when 2 lawyers appear and, canvass their case. Obviously, the judge is bound to be persuaded. So that's the whole art, no? I mean, in a way, it is true.
And you know why?
Input,
Because you have seen much more of the world than many of us.
So many a times input depends upon the output. Suppose if the defense lawyer is extremely good and the prosecution is weak, there's a lot of burden on the judge to decide the matter. I mean, the kind of public prosecutors, with great respect, there are many outstanding, but you know what the thing is?
You made a very valid point.
As Advocate General, I have myself seen it, the different experiences. Even as ASG, I have seen the public prosecutor must also assess the case,
You made a very relevant point, which I'll take to Senior Advocate Yuthal Luthra. Senior Advocate Atmaram Nadkarni spoke about the role of a public prosecutor. Prosecution is weak, the accused may get away. But wrongful prosecution may also mean that somebody innocent may be sent to jail. We don't think that doesn't happen. If we look at the experience, there are a lot of talks in hushed tones that many times even the innocent or innocent may get convicted. I want to understand that from you. Is the dilemma that you of course you become over a time a bit you cut yourself off from your court life and home life, because obviously if you think about these things you may not be able to function normally. Do you think that this is a dilemma of a judge and also of the lawyers appearing before the courts of law?
See, it's more a dilemma of the judge than of necessarily, for example, the defense lawyer.
Yeah.
I think it should be a dilemma of the prosecution lawyer, which I feel sometimes they don't discharge. I feel as a prosecutor, to see fairness rather than conviction is the job of the prosecutor. And sometimes I see that in their desire to get a conviction, they sometimes pad some of the truth. Now, that is why there has been this whole argument, should we have a revamp of our criminal justice system? Should we have one judge actually ensuring that the prosecution is fair and another judge then doing the trial? Why is this argument going on? Because ultimately, sometimes the same truth or material is not available to the defense, is available to the prosecution, but the prosecution brushes it under the carpet. So your question with regard to competence, I am not commenting on. Ultimately, we all come from the same ilk. Some become prosecutors, some become defense counsels. So I can't comment about the competence or capability. What I do say is, of course, everyone has a duty to the criminal justice system, but the prosecutor, because sometimes he has far more material. For example, and you have told us not to get into the facts, in this case, one of the aspects that comes out is that there was a fight and this man, PW2, hears the fight. Now, does that make out a case for 304 and not 302? I mean, these are questions which I sometimes, when I read a judgment like this, sometimes ask myself, should the prosecutor have looked at that? But no, our system somehow looks that the prosecutor should try and get the maximum sentence rather than the best justice.
Point well taken. I'll go to Senior Advocate Sheshadri Naidu. Sir, when you served as a judge of the high courts or various high courts, I would want to understand from you, do you face this dilemma, for example, on the A side where the prosecution seems disinterested in pursuing a matter, then you feel that an accused may just go away. And sometimes, when it so happens that you may get a feeling that something is not right, but everything is good on paper and you end up convicting somebody. So some innocent may get convicted. Do you think that you go to bed taking all those hard decisions that you have to take day in and day out, and eventually it's not so easy to go home with such decisions? Can you share that, your point of view with us?
Thank you, Tarun. That's a very good question indeed. But before that, let me tell one small thing. The most refreshing feature about the judgment, its brevity.
Yes, yes, I love
seeing
it.
the judgment.
I,
Worldwide, the length of the judgments across common law countries has increased by 30 to 50% thanks to cut and paste.
right.
And in this case, conspicuously, that's been avoided.
Yes.
What's to be said has been said very succinctly. Earlier, there was a purpose in judges quoting from judgments, paragraph after paragraph, because those days, that's beyond the digital age or before the digital age, there was no ready access to that material, so that to put that in context, they were quoting in extenso. Nowadays, with a smartphone, you could access everything. Giving a clue and putting a sentence or two, the crux of that matter will do. With that one, the readability increases and the clutter could be reduced. And this judgment has eminently achieved that. That's my opinion.
That's a good.
Now, let me come to the dilemma.
Yes.
That what do you call Hamletian dilemma, to be or not to be? Yes, every judge does have this dilemma. When I was practicing in Hyderabad, we used to have a wonderful judge called Mr. Justice Bilal Nazki. And in an interview, he told, then I was an advocate, I never realized the import of that statement. What he said, many a times I started dictating the judgment with a conclusion in mind. But as the narration went ahead, as I marshaled the facts and tried to apply the law, the conclusion became converse. Yes, because sometimes the novelist will say, the story has its own heart, its own plan. It is led by the two characters. And that's true as far as the judges are concerned. And when it comes to my experience, yes, there were a couple of occasions when on the first blush, after hearing the case, I declared the result saying that this is going to be the outcome. You will have the judgment by evening. Then retired to my chamber, I started dictating. I had to eat my words because I found something contrary and I could not convince myself. It's either my bravado sort of thing that I should stick to whatever I've declared or answering my conscience. I answered my conscience and I went back, reopened and reheard and reversed my own decision. It always happens when it comes to dilemma. The third question you said is whether we go to bed carrying our judgments. Yes, some do. Perhaps I was one of them.
Thanks for sharing that opinion. I will go across to Niharika Karanjawala from Karanjawala and Company now. You belong to a law firm that handles many such matters on a day-to-day basis. What eventually happens is you are with a board of hundreds of matters with you. And of course, there are judgments that are pronounced. But obviously, you're going through these files and seeing what happens to each person in this case. Do you feel that the judges have a really tough job in there because, you are taking these matters to them, they are delivering judgments? What do you feel from a law firm standpoint who takes a lot of these matters to courts, mainly in your case, the High Court and the Supreme Court more so? Could you share that with us? Because day in and day out, you take these matters, decisions are announced. Does one get to appreciate the duty that the judges have been performing? At least when these are matters of life and death. It's not a matter of some compensation that you put 5, 10, 15 lakhs and you move ahead. Nobody loses much. But in matters where somebody will be incarcerated for years together.
Absolutely. Certainly, Tarun, I think you raise a very interesting point, and especially in criminal matters where there are questions of life and death at stake, I think the burden and pressure upon the judges that try these matters is huge. And I also think that often they don't get the recognition and the admiration that they deserve for it, because very often, especially in cases that get a lot of media attention, yes, the general public decides very clearly what its views are, and very often those views are not based on the actual facts or evidence. Of course, they haven't seen the evidence, but on gut instinct and on things they see in the news and such like. And in that situation, you have a predicament of not only does a judge have the very the very large burden of dispensing justice in a case where stakes are very high, but the fact is, depending on how the learned judge holds, they may themselves be subjected to a lot of scrutiny and a lot of questioning as to, why has this decision been reached? And I think what is important and what is very significant is that we be able to trust our justice system. I think it's important that the general public trust our courts, trust our judges. And the justice system isn't perfect. From the stage of investigation onwards, there's a lot we can do to improve it. There's a lot that investigators can do to improve their craft, to make sure that they face no biases in their investigations. As Geeta ma'am rightly brought up, there's a lot that prosecutors can do to ensure that they are fighting for the dispensation of justice itself and not for the prosecution strictly of an individual who may or may not deserve it. And there is a lot that defense lawyers can do to ensure that they remain within the truth and the evidence there. You fight your case as hard as you can within the evidence that you have. But ultimately, I feel, and as you spoke about skepticism earlier, ultimately, I feel that to the general public, there is a growing skepticism against our institutions of justice, which causes a lot of negative backlash against judges. Theirs is not an easy job, and there is a tremendous amount of talent on the bench. There is a tremendous amount of hard work that goes into parsing all of this evidence and making these tough decisions and going through pages and pages and pages of evidence and medical reports and arguments and things like that, and ensuring that you're not carried away by either your own biases or simply by the face value of a lawyer before you or something like that, and restricting yourself strictly to the evidence, because you're ultimately holding the life of an individual in your hands and you have the power to save it or to destroy it. And the fact is, I do certainly feel that the judges are not given the recognition they deserve for carrying out such a difficult job. And in answer to a question you brought up several minutes ago about, is the evolution of society responsible for this dilemma? I feel that this dilemma of balancing between a victim and an accused, this is the dilemma that has been with the criminal justice system and with the system of trial from the very beginning. It has nothing to do with the evolution of society. It is the same dilemma that has been there from the beginning. And what the prevalent legal wisdom has been on this is, even if 100 guilty men are freed, it is better than if one innocent man be denied their freedom. In which case, I feel that that is what we always have to return to. And that is what we always have to remain loyal to.
Thank you for sharing that with us. Today's has been a very wonderful and a good show. I like it because we discussed a part of society which involves a lot of lives. This is not a commercial issue. And I really appreciate, Senior Advocate Atmaram Nadkarni, Senior Advocate Geeta Luthra, Senior Advocate Sheshadri Naidu, and Niharika Karanjawala from Karanjawala Company for reading the judgment. I spoke to each one of you. You read the judgment. You spared time for this important issue. Thank you so very much. And thank you, viewers, for tuning in. Thank you so very much.
Thank you very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.